So it now falls to me to introduce our first keynote speaker. He has been a great friend of the journal. And for those of you familiar with the European Court and its jurisprudence, you will know very well who this individual is. I'm speaking about the former European Court of Human Rights judge, Paulo Pinto de Albuquerque. For me, as a human rights scholar and a teacher of human rights, I very often revert to the judge's separate opinions, of which he authored many during his time on the court, which was from 2011 to 2020. And one of them in particular that I turn to both in my own research and also whilst teaching students is the case of Volodina in Russia, because I think it typifies the judge's approach to rights and to understanding the intersectionality and the implications of rights jurisprudence and the function of the court. And in that case, in particular, he looked very deeply at the efficacy and the utility of rights as a protective mechanism for victims of domestic abuse and found them wanting. And I think that the judge foreshadowed really what ended up happening before the Grand Chamber several years later in Curtin, Austria. Since his time on the court, the judge is now a professor at the university, at the Catholic University in Lisbon. He has been a prolific speaker and writer, and again, he has been a great friend to the journal and has written extensively for us, and very recently published an article traversing the court's case law on migrants' rights and critically examining the backsliding that we're seeing in some of the court's jurisprudence with respect to migrants. And so we are incredibly grateful to have him here. We think it's a fantastic start to what we think is going to be a brilliant conference. And so with little ado, I'd like to turn now to the judge and let him take the floor.
Thank you so much. Can you hear me? Thank you. Can you hear me?
Yes. Yes.
Yeah, okay, perfect. First of all, thank you for the invitation. It's a pleasure to be with you. Thanks to the Center of Public Law, to Stephanie, to Stevie, to Kirsty, a long-time friends. Also to the European Human Rights Law Review Group. A word in memory of Jonathan Cooper, another great friend who introduced me to this amazing human rights academic group. My topic for today will be human dignity, the concept of human dignity in the court's case law. Excuse me. And my main point will be that there is a core to this concept, which we could find in the principles of equality and personal autonomy. And there is a side concept that has been incrementally attached to the idea of human dignity, which is vulnerability. So this is the contextualized interpretation of the court, which leads the judges to intimately connect these two concepts, the concept of human dignity and vulnerability. Human dignity features permanently in a vast array of international and regional human rights texts. Yet in the European Convention on Human Rights makes the European Convention on Human Rights makes no mention of it, barring one specific reference introduced in 2002 in the preamble to Protocol number 13 in the context of the abolition of the death penalty in all circumstances. The concept has, however, been richly assimilated in the court's case law. What I'm going to do is basically a review of this case law, critically reviewed. This is a work in progress. I should stress and underline that this is a text that Professor Pinar Olscher and myself are preparing for publication. So this is still a work in progress. It will be published, hopefully, in a couple of months. But I allow myself, we allow ourselves to present this preparatory text, just also to get the feedback from scholars and students. While this notion of human dignity is operationalized ab initio by the court and before it by the commission, references to it also appear in case law, with or without eliciting substantive engagement with it on the part of the court, where it is involved by applicants, respondent governments, or third-party interveners, promoted as a germane value in minority opinions, put forward as a benchmark in empirical information utilized by the court, and cited in case pertinent enumerations of national and international law. Article 3 and Article 8 in particular being the main locales in which dignity is deployed, the notion also features in case law with respect to Article 10 and less often Articles 2, 4, 5, 6, Protocol 1, Protocol 7, and eventually also Protocol 2. Dignity can play a different role in testing depending on the own architecture of provisions relied upon and the construct of complaints. Notably, the notion features in the determination of the scope of rights, but also in the assessment of compliance with limitation requirements and standards in the framework of both negative and positive obligations. Typically, it will be the dignity of applicants, what we are talking about, which is at issue. But sometimes the dignity of others, other individuals, other collectives, or other institutions can have relevance as a potential justification for restrictions of applicants' rights. My speech will focus on the former type of case law. In line with general rules of admissibility, the court will not receive dignity-related actio popularis complaints, particularly where non-transferable rights under Articles 2, 3, and 8 are concerned. In accordance with rules of representation, dignity-related complaints can only exceptionally, very exceptionally, be brought before the court on behalf of persons unable to do so themselves. Take the example of Valentin Campiano, where I wrote separately precisely on this issue, and Lambert. Close family members may have own standing to complain, however, on the basis of offense to their own dignity or rights arising out of inaction against their relatives. To date, the court has considered it neither desirable nor even possible to answer in the abstract the question whether the unborn child is a person and thus a rights bearer and holder of dignity under the convention. With regard to deceased people, we have seen the court in Perinchek recognizing as a legitimate aim of protection under the rights of others the dignity not only of present-day Armenians, but also of their deceased ancestors. The court has never provided an integrated definition of human dignity in all these cases, in this vast array of cases, as it understands it to reside within the ECHR. In a small subset of dignity case law, it uses a particular formula in deploying the notion, holding that the very essence of the convention is respect for human dignity and human freedom, sometimes in other words, but to the same effect. This formulation seems to be used where the court wishes to give particular force to dignity, to effect extensive interpretation or evaluative interpretation, or to underscore the importance of its findings. Different aspects of dignity become more concretely circumscribed where the notion is applied under and tailored to different convention rights. with or without use of the dignity-related very essence formula. All invocations of human dignity in case law being succinct, very succinct indeed, the full connotation of the notion in the court's case law is only to be derived through observation of the totality of its diverse applications. So it implies an analysis, a detailed analysis of the case law. On the rationale of the concept, the court likewise does not explain the rationale underlying its use of the notion. Very scarce sentences can be found on this. Human dignity having a prolific presence, not only in a wide range of other human rights sources, but also in the theory of ideas, of political ideas. The rich scholarship attending the concept can, however, aid the understanding of its function in the court's case law. Two main interrelated considerations therein are well reflected in the court's jurisprudence. First, in light of its varied and complex provenance, the notion of human dignity is at the same time open and subject to divergent understandings across time and jurisdictions. Secondly, not only is the substantive meaning of dignity as a total concept diffuse and variable, opinions diverge as to its format and status, as well as its utility in the interpretation of human rights law. While the court does not engage with the theory of ideas and surrounding human dignity, diverse applications in case law may be said to mirror various theoretical doctrines. The latter corresponding with different functionalities, the court's usage thereof can shed light on the purpose of their deployment in its case law. In one theoretical perspective, human dignity has no autonomous meaning and is fully synonymous with human rights. This view can be discarded in the context of the court's case law, in that human dignity clearly is not devoid of own content, of its own content. So it has an added value as a legal concept, although it is selectively, very selectively deployed in this sense. Indeed, in this understanding, human dignity does have its own substantive meaning, although in a bounded sense, in that it especially associates with and has intrinsic relevance for certain social themes and issues, like those that I have mentioned, the big umbrella being these issues of dignity connected with equality, personal autonomy, and vulnerability, but more specifically, they are connected, intimately connected with women's rights, poverty and welfare, health rights, bioethics, torture, slavery, forced labor, the right to education, the right to reputation, criminal justice rights, of course, control of access and use of personal data, sexuality, assisted suicide, even dwarf throwing, you name it. In this format, dignity functions, so in this standalone format with an added value in terms of the content of the concept, human dignity functions to delineate protection only in such spheres. This context-specific manifestation of human dignity is vividly observable in the case law in relation to the same and comparable issues that I've mentioned. The strongly topical role played by dignity in the court's case law gives rise to the question as to how the court perceives its format, whether it regards it as a right existing as an implicit dimension, or more loosely as a principle. Almost all references to the right to dignity or to the right to human dignity, UDOC search of these exact terms rendering respectively 52 and 50 and 34 results, appear in cited relevant national or international law sources. or are used by applicants or judges in separate opinions. The court itself very rarely configuring dignity in this manner. An exception lies in the context of violence against children and women under Article 3 and Articles 3 and 8, where the court stably refers to the dignity to human, the right to human dignity. As for its potential construct as a principle, whether or not the court considers dignity to operate in this manner, in deploying the notion, it does often juxtapose it with other principles and ideals it recognizes as grounding, grounding for the convention. For instance, the ideals and values of the democratic society, the other values expounded in the convention, the principles of equality, and also closely associated, the human freedom and personal autonomy concepts also prominently feature alongside the notion, particularly in case law relating to the right to choice with respect to health issues. Preeti, Albert, Ever Sain, Jivan, you name it. For social solidarity and the spirit of international and European solidarity and cooperation, you have some very interesting cases where dignity is invoked, like Van Mursela, J&A versus Austria. This case, it's a human trafficking case where I also wrote separately, and I tried to underscore this connection between the two ideas, the idea of international and European solidarity in the fight against human trafficking and human dignity. Given the open-ended nature of the idea of values underlying the convention, the court is able to recognize as included thereunder a great diversity of alternative principles and ideals. Problematic in this regard is that the connotation of dignity can differ depending on which particular principles it is associated with, also in line of potential conflicts between them. The question as to the format of the notion also has bearing on its status and impact. Some scholars attach great weight to the notion, considering to be the very foundation and moral source of human dignities and the key to the logical interconnection between the different categories invoked by the court's case law, or a fundamental value of human rights law, which should always play a core role in human rights interpretation. I'm referring to several doctrinal sources, where the court references human dignity has been linked to the very essence of the convention. It would seem to align itself with such doctrinal views, therein rendering human dignity quintessential in convention interpretation. Whether or not the court holds that to be the case is subject to debate, however. There are contrasting views on this. In any event, it is clear that the court maintains a multifaceted approach to dignity in case law, recognizing a diversity of topical meanings, allowing it to function in different formats and variably allocating the notion greater or lesser weight and impact according to the context. The intricacy thereof giving rise to difficulties in the delineation of its substance and impact. See in that light, for instance, the excellent article of Jean-Paul Costa on this same issue. Let me now turn to not to the evolution of the concept, but to the impact and weight of dignity in some specific contexts, like, for instance, the Article 4 context. Beyond the themes already mentioned, dignity features as an important, essential factor in this context of Article 4. Here, dignity plays a fundamentally strong role in that all forms of ill treatment, and specifically this particular form of ill treatment, which is slavery and human trafficking, are considered to be an affront to human dignity, with no further relativity in testing. This is very clear from the references in Rancef and versus Cyprus, or in Jay and others versus Austria. The greater relevance in the diverse provision of other notions and principles will also impact the context-specific dimension of dignity at issue. Whereas dignity strongly interplays with vulnerability in most contexts, a principle such as that of personal autonomy, which can conjoin with dignity to create special spheres of protection, is more readily operational in Article 8 and Article 3. These articles, as evidenced by the strong representation of these provisions in dignity case law, they represent a value of civilization. This is the expression of the court, which is closely bound up with dignity. This is the court speaking Mercic versus Croatia, another case where I was a member. Again, in my separate opinion, I also stress this intimate interconnection between the two concepts, vulnerability, in this case of detainees, and human dignity. Dignity may, as such, be offended through all forms of treatment prohibited in these articles. The dignity-based foundation of the provision becomes more visible at the lower end of the scale of gravity, however, where degradation is concerned. Such forms of degradation are concerned, notably in the absence of actual bodily injury or intense physical or mental suffering. Here, it's where the concept plays a major role. Where the severity threshold for instance, for Article 3 or 8 is not reached, then for Article 3, then dignity issues arise under Article 8, and Article 8 can function as a fallback basis of protection. An important thematic mainly addressed under Article 3 concerns situations in which persons are under the control of law enforcement agents or other figures of authority, particularly where the privation of liberty is at issue. Vulnerability and sensitivity to ill treatment by default being in such circumstances following Bohit. In this type of short-term interactions, the court deploys alternate approach in assessment focusing rather than on the actual severity of treatment, on the strict necessity of acts or measures in light of the own conduct of the person, the detainee. This allows for broader applicability of Article 3 to lesser forms of ill treatment. Again, other examples can be found, for instance, unnecessary handcuffing or subjection to racist remarks in the prison context. All of these in one way or another connected with the concept of dignity. For the fallback role of dignity in Article 8, in context of short-term interactions with respect to entry of residents, see, for instance, the Cusera case, the Vinks and Rebecca case, where this is particularly a very good argument of the court to make its point related to the violation of Article 8. Discriminatory elements always being an aggravator in identity checks the court holds under Article 8 in conjunction with Article 14 that racial profiling negatively affects, and here I'm quoting the court, the dignity of the persons concerned, Basu, Muhammad, and other similar cases. By the way, there's a very important case, Muhammad versus Romania, again, a Grand Chamber case where I was a member of the composition, where the discussion on human dignity is approached from the majority side in a very utilitarian way, and you will find in my separate opinion, an opposite view, a more essentialist view of this concept. So the discussion is between this majority view, very utilitarian oriented interpretation of the concept, and on the other hand, my view, more essentialist. And when I say essentialist, don't get me wrong. Of course, I'm not. I'm not saying that there should not be a contextualized interpretation of this concept, especially when related to vulnerability. It's precisely the opposite, the message that I'm sending. But I think that the need for a contextualized interpretation does not prejudge your position on the discussion whether the concept is or should be approached in a more utilitarian or essentialist way. In longer-term deprivation of liberty under Article 3, regardless of intent to humiliate or debase or the financial or logistic difficulties, states must ensure that the conditions are, and again quoting the court, comfortable with respect for human dignity, meaning that the intensity of distress or hardship may not exceed the unavoidable level of suffering inherent in detention. Again, Mursic speaking. Obligations in this regard also apply to pre-trial detention, especially long terms of pre-trial detention, as well as to the transfer to and detention in courthouses for hearings or cramped transport conditions. And this taking into account previous CPT standards recommendations. Case law prescribing detailed standards for material detention conditions. Dignity can also be offended as a consequence of treatment in special penitentiary regimes. For instance, the Polish case Petrovich on the sensory and social isolation and the absence of mental and physical stimulation, which was found in breach of human dignity, or the fully body strip in the old case Van der Ven, followed by a string of other subsequent similar cases. While Article 3 does not entail a right to compassionate release for ill prisoners, health and well-being must be secured, including the provision of requisite medical assistance in order to provide for their human dignity. Medical treatment must be at a level, and I'm quoting the court again, comparable to that which the state authorities have committed themselves to provide to the population as a whole, although not at the same level of medical treatment that is available in the best health establishment outside prison facilities. And this Ruman has set based on the human dignity concept. Obligations in this regard can range from a duty to transfer to civilian hospitals to resolving conditions which are only problematic in light of specific health issues or specific needs of a certain person, such as, for instance, a detainee suffering from asthma. Dignity in Article 8 context, again, as I said, provides fallback protection in this context in relation to particular issues which may not suffice to attract the applicability of Article 3. For instance, the way the cell is organized, the sanitary facilities within the cell. This has been dealt with not under Article 3, but Article 8, relating to the privacy of the detainee and its his or her own human dignity. The distinction between Article 3 and Article 8 not only hinging on gravity, the further protection of family life and correspondence in Article 8 can also engage dignity in the context of a detention. The ability of prisoners to maintain contact with close relatives being an essential part of the right to respect for family life. It's the court speaking again, Danilevich. The court invoking the same evolution driving the absolute life sentence case law also fortified proportionality standards with respect to restrictions based on human dignity. For deprivation of liberty or confinement outside a criminal justice context, you have, for instance, social care home cases, conditions in the social care home cases, for instance, cases, very interesting cases related to the protection of persons with mental disorders. Stanev, for instance, of course, Junzer, the famous German case, Grand Chamber case, also a Grand Chamber where I was a member of the composition. Again, the interconnection between human dignity and the critique of the conditions of care for persons, in this case, highly dangerous persons with mental disorders, was stressed in my separate opinion. The interconnection and interrelation between Article 3 and 5, the latter provision also being violated for in cases where the court, if not directly using the concept, at least refers to international instruments for the protection and people with mental disorders under either under Article 3 or Article 5. Article 3 also prescribes important duties with respect to migration control, related confinement. So not only, and I'm referring here to the confinement outside of criminal justice context. So it's a crucial element, this human rights friendly interpretation based on human dignity as a way of criticizing the court's case law on migration control related confinement. In the light of the absolute nature of Article 3, the court has stated that the increasing influx of migrants and objective difficulties arising in that regard, and I'm quoting again, the court cannot absolve a state of its obligation to guarantee conditions that are compatible with respect for human dignity. This is Claifia against Italy. This is not very frequent, but has been also used in a couple of other cases. Darbo and Camara versus Italy, ZA versus Russia, HM versus Hungary. not very frequent instrument, but when it is used, it is a powerful argument of the court to ground its findings. The duty to ensure quality of life in certain respects takes on particular significance under Article 8 in conjunction with obligations to preserve human dignity. Under this heading, the Convention does not provide, for instance, for a right to own, to a home. The court has said so in a couple of UK cases, let alone a specific home or category of home. There only been a limited obligation to house the homeless. That the court has already stated. And here again, using the concept of human dignity. Living conditions nevertheless can give rise to issues such as overcrowded and unsanitary conditions caused by authorities' inaction or even by public action, like for instance, pollution, water pollution. And these, of course, raise an issue of human dignity, and the court has connected the two subjects. In MSS, the court found a lack of respect for the dignity of the applicant as an asylum seeker by Greece in relation to his homelessness and destitution in that country, as well as by Belgium for knowingly exposing him to such treatment by transferring him to Greece. So one of the main issues in MSS was exactly the fact that the person would be an homeless person. In Lakatos, the recent case, the court holding that prohibition of and punishment for begging can seriously compromise human dignity, paragraph 56, held that the right to turn to others for help falls within the very essence of the rights protected by Article 8. Extremely interesting line of argumentation, finding that the human dignity of the applicant as an extremely vulnerable person had been undermined. Paragraphs 58 to 60, very rich argumentation, repeated in paragraphs 115 and 117. I'm getting to the bottom of the line. Let me just refer to one final group of cases related to medical treatment outside the context of detention or confinement. So I refer to the right to a home. I will now refer to the right to health. By reading the case law, and especially the two very important Grand Chamber cases of the court, Lopes de Souza Fernandes and Fernandes de Oliveira, Lopes de Souza Fernandes and Fernandes de Oliveira, the two main cases in the court's case law on the right to health, that was the most important point on my agenda when I came to the court, was really to enshrine in the convention, enshrine in the case law, a right to health. I could not convince my colleagues. I did my best. I brought the two most important cases that I had in the Portuguese division, extremely important cases, not only for Portugal, but for the entire Europe, Lopes de Souza Fernandes and Fernandes de Oliveira, one related to medical negligence and another related to inhumane treatment of mentally disturbed persons. This I did on the basis that the right to health could and should be guaranteed by the convention if connected to the concept of human dignity. You'll read that in my separate opinions in both cases. In both cases, I voted as a dissenter. because, as I said, I could not convince my colleagues. But it is important. I think a jurisprudence that may eventually, in the long term, will prevail. I think, hopefully, which is a way of connecting the interpretation of Article 2, 3, and eventually also 8 with I would say a more generous understanding of the right to health in this, in the light of the concept of human dignity. In my dissent, I wrote that Articles 2, 3, and 8 positively oblige states to have in place regulations compelling both public and private hospitals to adopt appropriate measures for the protection of their patients' physical integrity, and in the event of medical negligence, provide victims with appropriate redress. Dignity and personal autonomy, again, being the driving considerations in this regard. Consent is primordial in this sphere. A corollary thereof being the duty of doctors to provide well-considered information as to the risks. This is more or less, I think I tried to explain that in the separate opinion, a sum up of what we could already read in the case law, but it was not stated. I didn't convince my colleagues, I could not convince my colleagues to state it black and white in the majority reasoning. So, thank you so much for your attention. I hope this was interesting for you. It was certainly, and is still certainly interesting for me. Again, I stress that this is a work in progress. We are writing, me and Dr. Pinar Olscher from Leiden University. We are writing on this topic. We have been discussing this for a couple of months already, and we hope to hopefully to have this done, finalized by the beginning of next year. Thank you so much for your attention.